Okay, thank you very much. I will re-begin. Good afternoon. I would like to call to order this meeting of the Committee on the Judiciary and Public Safety to order. I am Councilmember Brooke Pinto, representing Ward 2 and chairwoman of the committee. Today is Thursday, October 17th, 2024, and the time is now 4:37 p.m. and we are conducting this meeting virtually via the Zoom platform and streaming on the DC Council's website and on YouTube and X at @CM Brooke Pinto. We have a quorum today with at-large Councilmember Christina Henderson, at-large Councilmember Anita Bonds, and Ward 6 Councilmember Charles Allen. We have 7 items on the agenda today. Bill 25-135, the Illegal Dumping Enforcement Amendment Act 2024, Bill 25-219, the Uniform Powers of Appointment Act of 2024, Bill 25-224, the Uniform Trust Decanting Act of 2024, Bill 25-225, the Uniform Directed Trust Act of 2024, Bill 25-484, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act of 2024, Bill 25-485, the Uniform Commercial Real Estate Receivership Act of 2024, and last, Bill 25-486, the Uniform Community Property Disposition at Death Act of 2024. We'll take these measures up in turn, starting with Bill 25-135, the Illegal Dumping Enforcement Amendment Act of 2024. This bill was introduced on February 10th, 2023 by Councilmember Gray, along with council members Bonds, Fruman, Henderson, Lewis, George, McDuffie, Parker, Tran White, and myself, and was sequentially referred to the Committee on Public Works and Operations and the Committee on Judiciary and Public Safety on June 6, 2023. Councilmember Nadeau and I held a joint public hearing on the bill on June 27, 2023, and the Committee on Public Works and Operations marked up this bill on September 24th, 2024, and that committee voted unanimously to advance the bill. Illegal dumping is a significant problem in the district, one that disproportionately harms low-income and disenfranchised communities. In 2022 alone, there were 14,000 311 service requests related to illegal dumping. In many cases, these are not minor items being discarded. In the past few years, there have been news reports of, quote, a mountain of discarded tires in Anacostia Park, broken ATM machines in Watts Branch Creek in Northeast DC, and multiple cars being found on public land in Ward 8. All 3 of those examples were from east of the river. In testimony on this bill, OIG noted that in 2022, 5 of 6 zip codes that had more than 1,000 311 requests related to illegal dumping that was taking place in majority minority communities. This bill marks significant steps towards strengthening our ability to combat illegal dumping in the district. Under current law, individuals who violate our prohibition on illegal dumping are subject to criminal penalties, but there is no civil penalty for a fine. This bill gives the Office of Attorney General authority to bring civil lawsuits against individuals or companies who are found to have violated the illegal dumping law. OAG believes the authority in this bill gives it more powerful tool for curbing illegal dumping in the district. The bill also expands the definition of solid waste in the illegal dumping law to explicitly cover items that are commonly discarded, like tires and mattresses. These materials are already covered by a catch-all in the definition, but this change will help avoid possible litigation on that issue in the future. I do want to quickly note some minor changes that we made in this bill, in this committee. In addition to a handful of drafting changes, we made one addition to repeal a definition of the term guardian in the Female Genital Mutilation Prohibition Act of 2024, which the council passed in July of 2024. This change just corrects an inconsistency in the law and aligns the law with the legislative intent. This bill closes a significant gap in our current prohibition on illegal dumping, which allows OAG to go after the most serious offenders, many of which are likely corporations and repeat offenders, and will help reduce environmental harms inflicted on our most vulnerable residents. With that, I will move the print and report of Bill 25-135 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? All right. We will call a vote. We'll do this by a voice vote. All those in favor, please signify by saying aye.
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 The vote is unanimous. Measure is adopted. Next, we will move to a set of 6 bills proposed by the district's Uniform Law Commission, otherwise known as ULC. ULC provides states in the District of Columbia with nonpartisan and well-workshopped legislation that aims to clarify, regularize, and stabilize critical areas of state statutory law and to facilitate the proposal of uniform laws to the district. The 6 ULC bills before us span issues related to trusts, estates, and probate, civil remedies for survivors and victims of non-consensual pornography, receivership and commercial real estate, and the disposition of marital community property at death. These bills were introduced by Chairman Mendelson at the request of the Uniform Law Commission on March 16th, 2023. The legislation was referred to the Committee on the Judiciary and Public Safety on March 21st, 2023. The committee held a hearing on all of these bills on June 17th, 2024. I'll note in advance that the committee prints largely retain the language of these introduced bills. This is due in part to the fact that these laws are meant to be uniform and that uniform bills are informed and designed by over 350 volunteer commissioners and legal experts who substantially and carefully workshop these bills. We also received no opposition to the substance or language of the introduced bills. The most substantive change we've made is to Bill 25-225 on directed trusts by adding a streamlined trustee release mechanism consistent with our neighboring jurisdictions, Maryland and Virginia. This will ensure legal uniformity with our neighbors and contribute to the clarifying, modernizing, and codifying of our trust law. First, Bill 25-219, the Uniform Powers of Appointment Act of 2024, will clarify and codify the existing common law regarding the inauguration, revocation, and implementation powers of appointment in wills and estates, documents, and procedures. An appointment in this context refers to a non-fiduciary third party who acts alongside a trustee to supervise trust property distributions. Codifying the rules around powers of appointment will give a sense of clarity and consistency to this adjustable estate planning tool. This legislation has been well vetted by the appropriate legal experts and well received in at least 13 other jurisdictions, including Virginia, and will be a helpful update in our law. I will now move the print and report of Bill 25-219 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? All right, we will have a voice vote. All those in favor, please signify by saying aye.
Aye.
Great, the ayes have it unanimously. The measure is adopted. Next, Bill 25-224, the Uniform Trust Decanting Act of 2024, would clarify and codify the rules and limits on a trustee's power to decant assets held in trust. In trust law, decanting refers to the act of transferring or decanting assets from a particular type of trust whose terms are unchangeable, otherwise referred to as irrevocable, to another. Decanting is necessary when, due to unforeseen circumstances, the intent of the settlor of the trust cannot be fulfilled unless the trust assets are put into a different trust or put into a modified use that still fulfills the settlor's original intent. If the settlor's trust is irrevocable and the settlor has passed away, decanting allows for the trustee to fulfill the settlor's intent by putting or pouring the assets into another trust. This bill also imposes limits on a trustee's decanting of a trust in order to make sure that the trustee is truly honoring the settlor's purpose and protecting the beneficiary's interest. For example, a trust dedicated to charitable interests could not be diminished or exterminated through decanting. Likewise, a trustee would not be able to decant from a trust without notifying the trustee and ensuring that the trustee's interests must be protected. Last, successor trustees would be protected from liability for past decantings of prior trustees by being able to take those past decantings as valid. Decanting needs to be clearly formalized and regularized in order to allow for flexibility in trust and estate planning, while also circumscribing the trustee's powers to decant to ward off abuse of this device. Codifying the rules around decanting will give us a sense of clarity and consistency of this legal device and has so far been well received in at least 14 other jurisdictions, including in Virginia. I now move the print and report of Bill 25-225 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? Okay, we will take a voice vote. All those in favor, please signify by saying aye.
Aye.
Great, the ayes have it. The measure is adopted unanimously. Next, we'll turn to Bill 25-225. Excuse me one moment. Bill 25-225, the Uniform Directed Trust Act of 2024, which addresses the rise of directed trusts and clarifies and codifies the role of and rules governing trust directors. Directed trusts are a special legal entity that have both a trustee and a trust director. Director is a technical term. A director is someone who directs a trust or trustee, but who is not themselves a trustee. This bill also amends current law to add a legal clarification allowing trustees to distribute life insurance proceeds through a trust. This clarification avoids potential jurisdictional and legal conflicts that arise when defining an insurable interest and insurable life for trust administrations. One change we made to this bill is to add a streamlined trust release process that would allow for a trustee to release themselves from their fiduciary duties by sharing an accounting and notification of beneficiaries through certified mail when the trustee terminates there is a change in trustees. The beneficiaries would have 120 days to object to this release, otherwise the release would be finalized. This proposal is motivated by a desire to simplify the trustee release process, which can become burdensome when trustees must either file in court or obtain a release agreement from all of the relevant beneficiaries in advance. Trustees may have difficulty obtaining a release in this fashion, especially if they have multiple beneficiaries or if reaching those beneficiaries becomes too difficult. Both Virginia and Maryland have this provision. Virginia provides 60 days for an objection period, whereas Maryland provides 120. Consistent with the ULC's commitment to legal uniformity, I believe that the district's legal uniformity with Virginia and Maryland is important, so I prefer to adopt a provision already embraced by our neighbors. Still, I hear and share some concerns that trustee fiduciary obligations towards beneficiaries is paramount. We therefore opted to adopt heightened protections in the trust release provision that are more similar to Maryland's laws by including a lengthier timeline of 120 days for beneficiary objections required certified mailing and a narrowing of the circumstances under which trustees can use this streamlined mechanism. By opting, for 120 days and these other modifications, we have found a balance between administrative streamlining for trustees managing multiple beneficiaries and protecting affirmative beneficiary rights while maintaining robust trustee fiduciary obligations. I now move the print and report of Bill 25-225 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? All those in favor, please signify by saying aye.
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 Great, the ayes have it unanimously. The measure is adopted. Next, we'll turn to Bill 25-484, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act of 2024. This bill concerns civil remedies for victims and survivors of revenge pornography. The bill creates a civil cause of action for victims of unauthorized disclosure of private, intimate images, allowing them to recover damages. The bill also authorizes courts to grant a victim attorney's fees and other relief and would establish procedures to enable victims of such disclosures to protect their identity in court proceedings. I'm especially concerned about the harm of this unauthorized disclosure of intimate images known as non-consensual pornography and its disproportionate harms on cis and trans women, girls, and femme people. For example, in 2017, one study showed that over 12% of young Americans aged 18 to 19 were victims, with recent trends captured between 2016 and 2022 showing an exponential increase in rates of revenge pornography with the rapid spread of social media. Non-consensual pornography disproportionately victimizes young women and LGBTQIA+ communities, with between 60 to 70% of victims being women and LGBTQIA+ individuals experiencing victimization at a rate of 7 times higher than other identifying individuals. For victims, the effects are long-lasting and it can have devastating consequences on mental health, social and occupational interactions, and personal safety. The committee print of Bill 25-484 retains the language of the introduced bill, for the most part, makes a few clarifying changes in the exceptions to liability section. This civil law will complement the changes we made to our criminal laws around non-consensual pornography in Bill 25-345, the Secure DC Omnibus Amendment Act, passed by the Council and enacted in June of last year. There, we made revisions to the criminal code on non-consensual publication and disclosure of intimate images to close legal loopholes. Specifically, the provision removed an agreement or understanding standard that the sexual image is not to be disclosed when a complainant brings a case for non-consensual dissemination of sexual images, which had made cases especially challenging to prosecute. Bill 25-484 is similar in spirit in that it facilitates a victim's access to justice by giving her a right of action to seek civil remedies against a perpetrator who has unlawfully disclosed her intimate images. By enacting this law providing civil remedies, the district will continue to be a leader in the protection of women, girls, and femme people from non-consensual pornography. I now move the print and report of Bill 25-484 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? All right, we will take a voice vote. All those in favor, please signify by saying aye.
Aye.
Aye. Great. The ayes have it unanimously, and the measure is adopted. Next, we'll turn to Bill 25-485, the Uniform Commercial Real Estate Receivership Act of 2024. This bill would clarify and codify common law regarding receivership for commercial real estate. A receiver is a court-appointed individual taking possession of or management over another person's property. For commercial real estate, a receiver is appointed when there is litigated property that must be maintained during a lawsuit, when an operating business needs to sell its assets efficiently, and upon request from a creditor with respect to a defaulting or insolvent debtor. This bill provides clarity and consistency for commercial real estate receivership in the district that will likely expedite and facilitate the legal process of receivership, allowing litigated property to be maintained, business assets to be efficiently sold, and consumer tenants' rights to be better protected when property falls under receivership. I now move the print and report of Bill 25-485 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? Okay,
Yes.
go ahead. Councilmember Bonds? Councilmember, you're muted.
All right, can you hear me now?
Yes.
Okay, great. I wondered if we should anticipate into the future receivership regulations as it relates to, or even a bill as it relates to receivership for residential properties, since I could not find anything in the code at this point. I've just wondered if there have been some discussions about that. And I know that that process occurs periodically and could continue into the future.
Okay. Well, thank you for raising that. This bill covers multifamily properties as well for commercial real estate receivership.
Okay.
But as a separate matter, would be happy to speak with you about how we make sure that we are protecting other residential properties in a similar way.
All right. Thank you. Thank you very much.
Thank you. Sorry, I'm just receiving a note that's reminding me that this bill that we're passing does not impact the Tenant Receivership Act. And we talked a little bit at the hearing about other protections for residential properties as well. So we can certainly follow up.
All right. Thank you.
Thank you. Is there any other discussion? Okay, we will take a voice vote. All those in favor, please signify by saying aye.
Aye.
Aye. Great. The vote is unanimous. The ayes have it. The measure is adopted. And lastly, we will turn to Bill 25-486, the Uniform Community Property Disposition at Death Act 2024. This bill would clarify and codify the default rules concerning the equitable distribution of property. A minority of states in the US, about 9, follow a community property regime in which a married couple retains shared rights over their property. The district is not such a jurisdiction. However, when married couples relocate to the district who formerly lived in the community property jurisdiction, there have been probate and estate planning issues upon the death of one or both members of the couple. In order to ensure that the district probate court and/or trustees properly recognize the community property status in a decedent's estate in the district, and to avoid potential litigation among the surviving spouses and heirs, this bill would set up rules regarding the equitable distribution of community property and would allow the court to determine the character of the property when there is a dispute among heirs. The bill would also clarify how property is to be distributed when a couple mutually agrees to separate, provide a remedy for bad faith transfers, and provide rules for non-probate transfers to ensure the proper disposition of community property. I now move the print and report of Bill 25-486 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? Okay, we will take a voice vote. All those in favor, please signify by saying aye.
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 You. The vote is unanimous. The ayes have it, and the measure is adopted. That concludes the business for today's Committee on Judiciary and Public Safety. Unless members have anything else they would like to raise? Okay. The time is now 4:57 p.m.